July 24, 1974. A unanimous Supreme Court is preparing to rule on whether the President of the United States must hand over secret recordings of his own conversations. 16 days later, he will resign. The court is about to do something no court had done before, formally recognize that the President possesses executive privilege. Yet in that exact same ruling, they will refuse to let him use it. The crisis began 2 years earlier, in June 1972, with a botched burglary at the Democratic National Committee headquarters in the Watergate complex, and the sprawling cover-up engineered to bury it. Investigators soon discovered that a voice-activated taping system had been running in the Oval Office. Raw audio evidence of the cover-up existed. The investigation was led by Special Prosecutor Leon Jaworski. He was appointed under a unique Department of Justice regulation that granted his office independence to investigate the president's closest aides. The grand jury had already named the sitting president an unindicted co-conspirator. A criminal prosecution demanded evidence, and the absolute best evidence was currently locked securely inside the locus of executive power. The country faced an operational test of whether any person is above the law. Jaworski moved under Federal Rule of Criminal Procedure 17C for a subpoena ducis tecum, a court order commanding a person to produce specified physical evidence. This was an incredibly precise demand. Because the prosecutor had obtained the White House logs, he could name the exact times, places, and participants for each recorded meeting. On April 30, 1974, President Richard Nixon attempted a compromise. He publicly released heavily edited transcripts of 43 separate conversations, while formally filing a motion to quash the subpoena to keep the raw audio hidden. District Judge John Sirica denied the motion to quash. He treated the tapes as presumptively privileged, but found that the prosecutor had successfully rebutted that presumption with factual evidence. Normally, denying a motion to quash is not a final, appealable order. The usual route for an appeal requires a person to defy the order and be held in contempt of court. But holding a sitting president in contempt was a constitutional boundary no one wanted to cross. The special prosecutor immediately petitioned for a writ of certiorari before judgment. He asked the Supreme Court to bypass the Court of Appeals entirely. The nation was fracturing, and the normal appellate calendar was too slow. The ordinary mechanics of civil procedure suddenly became a high-speed engine, racing directly against the timeline of an impending impeachment. Nixon's lawyers first argued this was a non-justiciable intra-branch dispute. Since both the special prosecutor and the president were executive officers, they claimed the courts had no authority to intervene. The court rejected this using a rule of administrative law known as the Accardi principle. This doctrine dictates that the government must follow its own validly issued regulations. The Attorney General had written a regulation giving the special prosecutor explicit, unique authority to contest a claim of executive privilege. As long as that regulation remained on the books, the executive branch was legally bound to the dispute. Nixon's second defense was bolder. Even if a court could hear the case, the president, and the president alone, was the final, absolute judge of what his privilege covered. To dismantle this claim, the court reached back to its 1803 ruling in Marbury v. Madison. Madison. They reaffirmed Chief Justice Marshall's famous command. It is emphatically the province and duty of the judicial department to say what the law is. By staking the power of judicial review against a sitting president, the court unequivocally established that the executive branch does not get the final word on the limits of its own power. But here is the turn the public rarely expects. The Supreme Court actually agreed with Richard Nixon on the existence of executive privilege. The justices acknowledged that a president needs candid, blunt advice to govern effectively. This need for confidentiality is inextricably rooted in the constitutional separation of powers. However, the privilege Nixon asserted was a broad presidential communications privilege. The court carefully noted he was not claiming to protect military, diplomatic, or sensitive national security secrets. While the privilege is real, the court ruled that an absolute, unqualified privilege would conflict with the function of the courts, cutting deeply into the guarantee of due process. To resolve this collision of branches, the court designed a constitutional balancing test. They weighed a president's generalized interest in confidentiality against the demonstrated specific need for evidence in a pending criminal trial. The specific need for evidence won. To protect both values, the court ordered an in-camera inspection. The trial judge alone would listen to the recordings in private, extracting the necessary evidence while keeping irrelevant conversations completely secret. The court forged a powerful constitutional shield for the presidency, but meticulously designed it so a president could never use it to hide criminal evidence. The verdict was unanimous, 8-0, with Justice Rehnquist taking no part. The Supreme Court ordered the President of the United States to deliver the tapes. That decision arrived on July 24, 1974. Forced to comply, the White House surrendered recordings that included the June 23, 1972 conversation, the smoking gun proving Nixon's direct role in the cover-up. On August 9, 1974, just 16 days after the court's ruling, Richard Nixon became the first president to resign the office. The constitutional privilege survived the ruling, but the man wielding it did not. The institution outlived the executive. In the legal academy, a loyal opposition emerged. Scholar Philip Kurland argued that the court strained legal logic to achieve a politically necessary result, effectively writing a decision to oust a president. Kurland questioned whether an administrative regulation that the executive could presumably rescind should have carried such massive constitutional weight, and he argued the court aggressively stretched Rule 17c to force compliance. Yet, over time, the ruling solidified. As legal scholar Jonathan Schaub observes, the court's qualified, balance-driven structure successfully became the foundational map for resolving inter-branch disputes today. The justices explicitly refused to decide everything. The ruling answered how executive privilege fares against a criminal trial, but it left the immense question of privilege versus congressional oversight for another day. United States versus Nixon did not end the fight over presidential power. It simply established the baseline rule. The president holds immense privilege, but the courts, not the president, draw the final line.